I am, just to start with a couple of technical things, I am recording this session, so we'll be able to create a link to it in YouTube, which means that we'll have a special page on the website that our Step 2 clients and their helpers can go to and click on the link and be able to see this. There's good news and bad news today. The good news is that this is the first time we've done this online through GoToMeeting. Or the good news is that we are doing this online, and we're essentially adopting a kind of a new platform for our education program, so that people don't actually have to come physically to our location. It does have its weaknesses in that it's sometimes easier to give a talk when you can actually see and hear the people who are in the audience. So, we hope that anybody who's on these calls coming in the future will feel free to break into the presentation and ask questions as they come along, because we like to have them interactive. The bad news is, of course, that this is also the first time that we're doing this online, so there are going to be some kinks, I'm sure. We've done a couple of these things in other contexts already, so we should be going along pretty well. Everybody who is calling into these online calls should be sure to mute their phones or their computers so that their feedback doesn't come through to everybody else. We've found that a lot of times there's if someone is breathing in their phone, everybody else can hear them. That's typically the most the ordinary thing that happens. But if you put the call on hold, we'll also get any music that you have in your hold. So it's better to if you don't have a mute button on your phone, just do style *6, and that should mute you in the presentation. So if this is an hour, we're going to be going from noon to 1. This class or presentation is designed to be a little bit more than an hour, so we'll try to keep it within the hour and have a few minutes for questions at the end if there are any. But don't hold it against me if we go over a little bit. We just have to sort of adjust these as we go along. So what we're talking about today is estate settlement, but estate settlement in the disability context. So just so that there's a review of where we are, for most people who hasn't actually been to our classes, we just like to start off with essentially the definition of estate planning to see where we are. And the definition is I want to control my property while I'm alive and well, plan for me and my loved ones if I become disabled, and give what I have to whom I want, when I want, the way I want, all while assuring my wisdom is transferred along with the rest of my wealth. And so in order to help people do that, we recommend that people adopt the 3-step strategy, which is to develop your plan with counseling-oriented planning partners, commit yourself and your loved ones to a formal and continuous maintenance and education program. That's the second step. And the third step is to secure appropriate assistance for you and your loved ones to transfer your wisdom along with the rest of your wealth. So the commit yourself and your loved ones to a formal and continuous maintenance and education program is the Step 2 program, which is what this class is part of. But we're aiming towards securing appropriate assistance for our clients and their loved ones to transfer wisdom and wealth. And so it's appropriate to focus a little bit on what we mean by appropriate assistance. And that is essentially the team of people who are going to take action when you become disabled or, unfortunately, if you die, to follow your instructions. And, an estate plan, if we're just thinking about the documents, that's just a stack of paper. What's really important is what people actually do. And so part of what we're trying to do is to educate the people who will take action for you, or we'll refer to those as your helpers, and so that they know what they're supposed to do, how they're supposed to do it, and most importantly, how they're supposed to pay for it. So we won't be talking too much about pay today, but that'll be part of what we'll be talking about as the classes go forward. So that's the three-step strategy. And so today we're in the Step 2 program, which is the formula maintenance program, and that consists of three essential ingredients. Updating the documents biannually, which we do for all of our clients. Some of clients are in 1 year, some clients are in another. And the purpose is that to make sure that the current documentation that our clients have accommodates changes in their personal financial affairs, changes in the law, and changes in techniques that we discover. We also have an asset funding review program, which happens in February and March of every year, where clients provide us with an updated list of everything that they have and with the values. And then the third component is training and education, which is what we're involved with today. So today's topic is disability, and so we're talking about, okay, what do we do now? This is part of our nuts and bolts program. So the model that we like to follow in our planning with all of our clients is to manage the transitions in planning, and the disability transition is one. Includes a personalized definition of disability. So all of our clients have the ability to decide how their disability is going to be defined. In other words, what's the standard? Controlling the decision-making process for that, and doing that through what we call the disability panel. We'll be talking a little bit about that. And providing private transfer to personally selected disability trustees. So all of our clients have their assets in their revocable living trust, but if they become disabled, successor trustees that they've appointed are supposed to take over. And so what we're trying to do is to have a private transfer of their assets from themselves as trustee to their personally selected successor disability trustees. And then, of course, as part of our model, we want complete personalized instructions for the key players about what they're supposed to do and how they're supposed to do it. So the key players in this scenario are the disability panel, and those are usually 3 or more people that are appointed by our client to be on a panel of people to make a decision about whether they're able to handle financial affairs or not, whether the client is. The way I like to think of it is, everybody knows I'm a little crazy, but it's what's crazy for me that I'm concerned about, and the people who know me well and who know when I'm acting in an unusually crazy fashion would be the people that I would want to have on my disability panel, so that they would know what was going on in my daily life and whether or not I needed some help. The next are the disability trustees, and those are people that are appointed by the client in establishing their trust, and the provisions of their trusts have a designation of who their trustees are. Sometimes those change over time, and that's why we have the updating program, but those are designated by the client. Then there is the healthcare agent or healthcare proxy, whose job it is to, and we'll be talking about what their job is, but their job is essentially to make healthcare decisions for the client. And then there's the attorney-in-fact, whose job it is to make certain types of financial decisions for the client as well. So if someone is disabled, it's important first to get information about what's supposed to happen. And so there are several different sources. The first, of course, is in the trust records. Everybody has a red book, which is what we call it. It's the red estate planning portfolio that everyone gets. And in that portfolio is a location list. Now, I've seen plenty of red books where the location list is not filled out, but the location list is a kind of a table of a lot of different locations with a list across the top of the different types of document. And actually the documents are listed on the left and the locations are on the top, and so our clients can designate where the particular documents are located, safe deposit box, attic, wherever it might be. And when you have your red book, it's the client's job to fill in the location list so that people who are going to take over for them know where everything is. So that would be like where the deed to the house is, where the insurance policies are, things like that, important documents, and they're all listed in the location list. That's a pre-printed form, and we like to have our clients fill that out. So if you're on this call or if you're listening to it later, be sure to remind yourself that it's important to check that location list to make sure that it's current. And also, of course, when we do our funding, which is changing the title to the assets so that they are actually held by the trustees of the trust, we get confirmations from institutions and other locations as to the fact that that change in title has occurred. And those funding confirmations, or at least the initial ones, are generally in the red book. And so it's important to make sure that your funding confirmations are there, and if you don't have them there, then we need to work on making sure that we have confirmations of all of the assets as they are titled in accordance with your instructions. The second source, of course, is the Step 2 program, which is what we're doing today, and that's us. So we provide information. We keep a lot of information for our clients, including how their assets are funded, what the value of the assets are, what their account numbers are, and that kind of thing, so that when someone wants to know and if they're supposed to take over what they're supposed to be handling, we can help them fairly quickly. And then, of course, there's medical professionals who will provide information on a medical basis, and we need the HIPAA waiver, which we update for everyone every year at the annual client meeting in the spring. So in the clients, we'll have what we call the Blue Book, and in the Blue Book, which has, it's essentially the guide to working in the Step 2 program and how we work with our clients through the Step 2 program, you will find the HIPAA waiver that people sign every year in the annual client meetings, so that that's always up to date. So then there's the disability panel. So who is the disability panel? Again, that's the people that, if it were me, I would pick, who know me well, know me in my personal daily activities, see me on a fairly regular basis, or at least communicate with me on a regular basis, even if they might be far away, and who will be aware that maybe something's wrong. So the disability panel are people that I select, and when they notice that there is a problem, that I may have the difficulty with handling my financial affairs, their job is to convene and get together and discuss whether they should determine that I'm disabled within the definition of the trust. And if they do, they sign a certificate that says that I am. So remember that this is not a determination of incompetence. Incompetence is something entirely different, although often somebody who's incompetent can also have difficulty with their financial affairs. What we're concerned with in the disability panel is purely a financial decision. Essentially, the disability panel pulls the trigger on some changes that occur in accordance with the client's instructions. So what the client has said is that if the disability panel determines that I'm not able to handle my financial affairs, then my successor trustees are supposed to take over. Now, we've never had a dispute in this with anyone. Usually people who are disabled realize that they need help, and they're very grateful to have someone else take over. So that is purely a financial decision, has nothing to do with the care of the person medically or their location physically where they're going to live. It's more about the financial circumstances. So what the disability panel should do is to review the definition of disability, and that's in Article 4 of the trust. They're supposed to make the decision based on observation, consultation, and deliberation between themselves. They can certainly consult doctors and each other and other family members, and then they make a vote. One of the reasons for having the HIPAA waiver updated every year is that members of the disability panel should be on the list of people who are mentioned in the HIPAA waiver, so that the doctors can actually, and other health professionals can actually talk to them. And usually the determination of disability is made by a vote unanimously of the disability panel. And so once that unanimous decision is made, the members of the panel sign what's called a disability certificate, and we use that to help in transferring the assets from the disabled trust maker or trustee to the successor trustees. And then, of course, their job is also to notify the disability trustees. Recently, we've had our clients sign a document as part of their updates that allows us to actually talk to the disability panel and the successor trustees, because, of course, the decision about the financial decision that triggers the change in trustees is a decision that technically is adverse to our client, the trust maker. But of course, all of our clients expect us to talk to the disability panel and the successor trustees so that we can guide them in the process of what they're supposed to do. And so we've asked clients to sign a waiver of attorney-client privilege and of the attorney relationship so that we can actually talk to the disability panel and successor trustees. So that's the disability panel. So one other thing to remember is that the disability panel does not cease serving when they make that initial decision, because what can happen is the person who is disabled, and that can happen if they have disappeared and we don't know where they are for a period of time, or they take a plane trip and they end up captive in Iran or some other foreign country and they can't get back. And also, of course, if they're not able, they're what's crazy for them, not able to handle their financial affairs for that reason. But it's quite possible for someone to become undisabled. And so the duty of the disability panel is to continue so that they can continue to monitor whether the person still needs the help. And it's important to know who has the power to remove and appoint successive disability panel members. That, too, is set forth in the trust. Sometimes it's the trust maker's spouse. Sometimes it might be a majority of the disability panel members. But in all cases, when someone is removed, the people who have the authority to remove them also have the obligation to replace them with someone who is not, place the person removed with someone who is not a successor trustee, but who also knows the trust maker personally and can have an understanding of what their circumstances are. So the members, therefore, can revoke the disability determination, and usually in our trusts, the revocation of disability is done by a majority so that it makes it easier to revoke the determination of disability. And then, of course, the revocation is done by a signed undisability certificate, which allows us to place things back the way they were so that the trust maker, the person who established the trust, can take over trusteeship again. Also, of course, a court may revoke the disability determination. That's necessary, of course, if there's an argument about whether somebody should be considered disabled and serve as trustee of their trust. But we've never had that circumstances and hope that we never do. But that's a nice safety valve in case there is a dispute about that. So the disability panel makes their decision, and the next thing that happens is that the people that the trust maker or client have appointed take over as the successor trustees and act and serve as the disability trustees while the client is disabled, while the trust maker is disabled. So let's just back up a little bit and talk about what's a trust. Well, a trust is essentially an agreement, and it's between three people, one or more trust makers. In our case, it's usually one trust maker. One or more trustees. Often the trustees are the trust maker and spouse, or the trust maker and a friend, or just the trust maker. And one or more beneficiaries. Now, the beneficiaries don't have to sign anything to be part of this agreement, because the trustees serve for the benefit of the beneficiaries. They hold and manage assets for the benefit of the people who are designated by the person who established the trust to be the beneficiaries. So there's three corners of every trust. So it's important to realize that a trust isn't just a receptacle. It's really an agreement between people that has obligations between them. So the trustee's job is to hold and manage the property, and he or she is supposed to do that to the benefit of one or more beneficiaries. And here's the most important part of it, that's to follow the trust maker's instructions. If the trustees don't follow the trust maker's instructions that are set forth in the trust, or at least the instructions as they're reasonably interpreted, then they're violating their fiduciary duty, which is the highest duty known in the law, as a trustee, and they're violating that duty to both the trust maker who established the trust and to the beneficiaries. Now, in the disability context, the trust maker is the person who established the trust, but also the person who is the current beneficiary because they are disabled. And so the successor trustees have been appointed, and their job is to manage the property for the disabled trust maker. Often the trust makers also designate other people in Article 4 of the trust who could be beneficiaries, so that if the trust maker's needs are taken care of, other people's needs might also be taken care of. So there are essentially three functions. The first is administration, and that is accounting for, you've received these assets, and so you're supposed to account for them. And what that means is, okay, here's what I received, here's what I did with it, and here's what I got left at the end of the accounting period. So that's one of the most fundamental trustees' job, is to account to the people for whom they're administering the trust, i.e. the beneficiaries, for how they've actually handled the money. Also, they have to do the income tax returns and other types of returns. And then, of course, the assets have to be managed, and that we mean investing and operating trust property. It might be investments in a brokerage account. It might be a piece of real estate. But essentially, the trustees have to manage whatever the trust holds and whatever's in whatever the property might be. And then, of course, the trustee's job is to make distribution decisions. I think I hear somebody asking a question. Hello?
No, sorry, Frank. I was calling something.
Okay. All right. Sorry. All right. So the other important decision that trustees make is how to make distributions. And essentially, they're making distributions to take care of the needs of the beneficiaries. They can make distributions to the beneficiaries themselves, or they can make payments to or for the benefit of the beneficiaries. So they might pay a bill. They might, if someone's in a in a hospital and there's bills that aren't covered by their insurance, the trustee could pay their bills. So the trustee's job in estate settlement is to manage the transition, and the one that we're talking about right now is the disability of the trust maker. So what happens? Well, we start off with the trust maker's funded living trust. And while the person is healthy, they're usually the trustee of their trust, and everything goes along fine. But there could be a disability determination, and when that happens, the disability trustees take over. So what their job is to take control of the assets, and the assets become assets of the disability trust. So the phase of the trust during the life of the individual, when they're healthy and everything's going along fine, that's represented by this box right here, can end in disability, or at least for a period of time. And at that point, that's when we get the disability trust right here. So when someone becomes a disability trustee, there's several things they need to do right to begin with. The first is they need to review Article 4 of the trust. That's where all of the disability instructions are in every trust that we've prepared for our clients. And then, of course, the next thing is to review what assets they hold as trustees, and to go collect and make sure that they actually hold them. Because normally, for example, in a bank account, the client will establish a bank account in the name of themselves as trustee of their trust, and then when they become disabled, they can no longer serve as trustee, so the disability trustees have to go to the bank and say, okay, we're now in control. And what makes the bank do that? Well, the bank has accepted the trust, and although they may have their own regulations about how they go about it, they have to follow the instructions of the successor trustees as long as they're verified and legitimate. So the next thing, of course, is to review the assets. And the way to do that is to start with the most recent asset detail report, which in our case is in what we call the Blue Book, or the operating manual for the Step 2 program, because when clients make their reports to us every year, they do that with what's called the asset detail report. We record what the changes that they've given us, and then in May or June, when they come to the annual client meetings, which are group meetings, we give them back an updated asset detail report, which goes in their Blue Book, which they have at the annual client meeting. Another place to find this information is funding confirmations in the Red Book. And another thing that many trust makers may have is something called an investment policy statement. Remember that if the trustee has a portfolio of publicly traded securities, they've chosen those securities through an investment policy. It may be written or it may be not, and they're going to have they may have an investment advisor, or they may be doing it by themselves. But in some way, they will have chosen their investments based on some form of policy statement. We always encourage our clients to have a written investment policy statement so that their successor trustees can follow it. What that ends up being is a kind of a safe harbor. If you follow the trust maker's investment policy statement as a disability trustee, nobody can criticize you for decisions that you made in accordance with the investment policy statement. But of course, as a trustee, you have the primary duty to decide what's the most appropriate investment policy and what the appropriate investment should be. So that ultimately is a disability trustee's complete discretion. The investment policy statement is really a safe harbor if it's established by the trust maker. And then, of course, the disability trustees should adopt their own investment policy statement. It may be congruent with the trust makers, or they may think they need to take in other factors and make some changes. Another thing is that the disability trustees need to obtain a new taxpayer identification number. When an individual trust maker establishes his or her own trust, the trust maker's Social Security number is the appropriate taxpayer identification number for the trust. That's under IRS regulations. As far as IRS is concerned, a revocable living trust, when the trust maker is the trustee, is invisible for tax purposes. They file their own income tax returns, the Form 1040. There's no changes tax-wise when someone establishes a revocable living trust. But when a person is no longer the trustee of their trust, in other words, when they have become disabled and they have successor trustees, now the regulations say we have to get a tax ID number so that IRS knows that there are people who are administering this property for the benefit of the trustee or the trust maker, and they know that there is potentially a new taxpayer. Now, for a disability trust, there's no new taxpayer. The report of the income is still the disabled person's income, but at least IRS knows who the fiduciary is who's supposed to do that, and that's why you have a tax ID number. And then the next step, of course, is to retitle the assets in the name of the disability trustees. In that, you may be dealing with institutions, and we need to provide a disability certificate. There may be an affidavit of trust. So for one of the things that our clients sign when they sign and update their documents is something called an affidavit of trust. It's an affidavit by the client and their co-trustee, if they have one, as to the name of the trust and a few other features of the trust, who the successor trustees are, and things like that. And parts of the trust are usually attached to the affidavit. So if there has been an affidavit signed by the trust maker and they become disabled, that affidavit is kind of a pointer to third parties to say, okay, who's supposed to take over? And then the disability trustees themselves sign a new affidavit of trust saying that they are now serving and that they'll provide copies of information as needed by third parties. So when we are asking banks and other institutions to retitle assets originally in the name of the trust maker as trustee, they may need an affidavit of trust so that they can verify who the appropriate trustees are, along with the certificate of disability that's been signed by the disability panel. And so what happens is that we try to we ask the institutions to title the assets in the name of the disability trustees. And I don't really mean asks, because eventually they are required to do so. They've accepted the trust's deposits, so they have to follow the trust terms. And the disability trustees actually step into the shoes of the trust maker or trustee. So now they are the owners of all the assets for the benefit of the trust maker who established the trust, who's not disabled. Now, another thing that successor trustees may be dealing with is real estate. In Massachusetts, if we file a certificate, something called a trustee certificate, which is a little different from a trustee affidavit, with the Registry of Deeds, the title runs in accordance with whatever the facts are that are set forth in that certificate. So in our trusts for Massachusetts property, we require successor trustees to sign and file a trustee certificate so that anybody who is running the title knows who the actual trustees are of the trust and who controls the property that's in the name of the trust. And then that gets filed at the Registry of Deeds. Again, we might have to file an affidavit of trust in connection with nominee trusts, and that's a little bit different because early on, before some laws were changed in Massachusetts, most of the property that was held by our clients through trusts were held through nominee trusts, so they didn't have to file their living trust, which might be 100 pages long, at the Registry of Deeds. The law was subsequently changed so that we don't need nominee trusts anymore, yet we still have clients who have property in nominee trusts, and that's fine. There's nothing wrong with that. But the successor trustees of the trust now become beneficiaries of the nominee trust, and they are in charge of making decisions about who the trustee of the nominee trust are. So they will make a vote as to who the successor trustee of the nominee trust might be if that was the trust maker. So let me make sure I'm in the right place here. Yes. So what the disability trustee does then is they manage the investments in accordance with the investment policy statement. And their most important thing, of course, is to provide for the trust maker. And those instructions about how the trust maker wants to be provided for are also contained in Article 4 of their trust. Now, note that it's capitalized there, and that's probably why that's for emphasis. The priorities for a trust, for the trust maker while they're disabled, is to take care of the trust maker first. They may have other people that they have designated as beneficiaries for one reason or another. Maybe they're dependent children, maybe their spouse, but the job of the successor trustees is to make sure that the needs of the disabled trustee or the disabled trust maker are actually met in accordance with the instructions in Article 4. But of course, with medical insurance and all the other things that people buy to take care of them while they're sick, long-term care insurance, it may be the trustees don't have to spend that much money, so money and resources may be available to other beneficiaries as long as the trust maker is taken care of. And then, of course, the disability trustees have to prepare accounts and tax returns on an annual basis. It isn't always true that they prepare accounts on an annual basis, but they should, and we recommend that they do. A lot of times the disability trustee is the trust maker's spouse, and sometimes they're serving alone. And in that case, oftentimes they don't prepare accounts. But if you're a third party, not the spouse of the trust maker, then you should consider preparing accounts while they are disabled. And of course, the tax returns have to be filed for the trust, indicating what the income of the trust maker is. So, next important helper is the healthcare agent or the healthcare proxy. So, what is the healthcare agent? Their job is to make healthcare decisions for the disabled person, sort of like a person who holds a power of attorney for financial purposes. And their power comes into effect when the medical people decide that the patient is unable to handle their financial affairs. Now, the healthcare agent is going to have the authority to make decisions about the care of the trust maker. And that would include medical care as well as the living conditions, where they might live, etc. And so working with the trustee, of course the healthcare agent by themselves doesn't have any money to spend for the disabled person. All that money is in the trust. So the trustee's job is to work with the healthcare agent, providing funding for personal health care decisions for them. And part of the instructions in Article 4 are to actually do that. So they might provide funding for custodial care and other living conditions as well. So let's talk about the healthcare agent. Now, the healthcare agent's job is designated by a document called, in Massachusetts, the healthcare proxy. Other states it's referred to as the healthcare agent or healthcare power of attorney. And it's a document that has a lot of powers in it, but often very few instructions. Now, in Massachusetts, or at least in our practice, we typically do not put specific instructions about how a person wants to be treated under certain circumstances. And we don't do that principally because in consultation with medical personnel, we have found that they prefer to have a spokesman on behalf of the family, but not to have specific instructions so that they don't have to parse the document, because it's not really what they like to do. They don't see themselves as having the job of determining whether the instructions that were written down by a person who's their patient actually fit the circumstances and make decisions on that basis. So they'd rather have an individual or individuals who are appointed by the patient to speak for them, and that's what the healthcare proxy is. Note that there can only be one healthcare proxy at a time, but we typically in our documents say if someone's not available to serve, then there's a succession of other people who can serve while the principal healthcare proxy is not available. So how then does the person who is speaking for the patient know what instructions they might have if those instructions are not in the healthcare proxy document? Well, that is the fundamental reason why we urge our clients to speak and talk with the people that they've appointed as their healthcare agent about what they want to have happen. And that goes right up to the decision about whether to turn off the machines during when a person becomes irreversibly ill. And there's lots of different circumstances that people might want to have considered. So actually having those conversations is probably the most important thing. I think maybe there are some people who wouldn't agree with me, but if I had a choice between having that conversation with the person who's going to be making those decisions for me and having the documents, I would choose to have the conversation first. Of course, if we can have both, why not? It's just that the document itself doesn't really give the person who's appointed that much guidance. So having those conversations and having a full understanding of what the person who's eventually going to be the patient wants is really important. So what the healthcare proxy does is they essentially speak for the family. Now the client can give them instructions to confer with the family, but ultimately that one person who's appointed has the complete discretion to make the medical decisions for the patient. And of course they're supposed to do that based on what their understanding of the patient, what the patient's instructions are. Now the next helper that's a chief one is the attorney-in-fact. The attorney-in-fact is appointed by a power of attorney, of course, and those can be fairly lengthy. We actually have 4 different powers of attorney that we have people sign. One's for tax purposes, one is a general power of attorney that sets forth a lot of different powers, and one of them is for funding, so that people have the authority to put assets into the trust. And then finally, one of them is what we call the general power that we hold in escrow. Now, it's important for people to understand that the basic power of attorney that we prepare for clients is something called a springing power of attorney. What that means is that it springs in, the authority of the attorney, in fact, comes into being because some event has triggered that. And the event, of course, is the decision of the disability panel. So a person who's appointed as an attorney, in fact, can attach the disability panel certificate to their document to indicate that they now have the authority to act on behalf of the principal, the person, the client, or the person who appointed them. Now, you might think about the fact that there may be long periods of time where a person remains the trustee of their own trust, needs a little help for one reason or another, but it's not appropriate for them to be removed on the basis of a decision by the disability panel. So what we do in that case is we have our clients sign a general power of attorney that is currently effective, but the document is held by our firm in escrow pending instructions from the client for us to release the power of attorney to the person who's appointed. So all they have to do is give us a call and say, look, I think I need some help, or I'm going away on a trip, so I'd like you to release the power of attorney to my agent so that they can act for me while I'm gone. So what does the attorney in fact control? Well, one of the most important things to remember is that if you have an IRA or a 401k, some form of retirement plan, and even some types of annuity, and there are some types of insurance that aren't owned by trusts, are owned by the trust, those retirement plans particularly cannot be owned by the trust. The trust can be a beneficiary, but the only person during the lifetime of the account holder or the participant is the participant who can actually make decisions about the retirement plan and how it's to be invested and whether distributions to be made, is the account owner or participant. So if they're disabled, how do those decisions get made, and how does the custodian or plan's trustee know what they're supposed to do? Well, that is a fundamental job of the attorney in fact. So it's important for the attorney in fact to know that they can make investment decisions in IRAs and 401ks. They can change designations of beneficiaries when that's appropriate. They can choose settlement options if it's necessary, or designate settlement options, because a lot of retirement plans, particularly corporate ones, have different options in terms of how benefits are to be paid on the death of a participant. And they can, of course, change the custodians. If there's an IRA and they don't like to have the IRA under the investments of the particular custodian, they can change the custodian. So they're acting for and on behalf of the owner of the retirement account, but of course if we transfer the retirement account to the control of the trustees, that would be an income creating event, because that would end up being a distribution of the retirement account to the trustees of the trust, and that would trigger income to the retirement account owner. So in order to control the retirement plans, we need to have an attorney in fact who has authority to deal with those kinds of decisions. And then of course there's also the need to collect and transfer assets to the trust. It's quite possible for a person to become disabled before they actually have finished actually funding their trust and transferring their assets to themselves as trustees. So in that case they're going to need some help, and we create powers of attorney that are currently effective that allow the persons who are designated the ability to transfer assets to the revocable living trust or designate the trust as a beneficiary of retirement plans and insurance, excuse me, so that ultimately the funding can actually be done even if someone is disabled. There's also other things like payable on death accounts. Those are accounts where someone holds the asset in their own name, holds the account in their own name, and they have designated, for example, their trust or some other beneficiary to take over the account when and if they die. So those are called payable on death or POD accounts. Also, we need the attorney, in fact, to deal with mail. If the client has to move because they moved somewhere else to a retirement community or something like that, we need to be able to submit change of addresses to the post office, and you can't really do that without having a power of attorney. So that's one of the powers that the attorney in fact needs to have, because the trustees really can't do that. And then, of course, there's Social Security payments and decisions and options about that. When someone goes through the period from age 64 to 66 or even 70, there are a lot of decisions that people make about whether and to what extent they're going to start taking Social Security payments. And if they're disabled during that period, it's up to the attorney, in fact, to help make those decisions for the person who's disabled. There also might be a need to withdraw property from the Revocable Living Trust, and the attorney, in fact, has that, because the only person who can withdraw money from the trust created by the trust maker typically is the trust maker. But if they have appointed somebody who's their, with a power of attorney, who's their attorney, in fact, that person also has the ability to withdraw money. Now, they might do that to make gifts. They might do that to make transfers to insurance trusts, because the trustees of the insurance trust need to pay premiums on life insurance. They might need to make gifts for children or grandchildren because of education plans, and if the instructions in the trust allow that to happen, then that needs to be done. And then, of course, there's Medicaid planning. Medicaid planning is kind of the reverse of estate planning in some ways, because property that's held in a trust is typically countable, even though if it weren't held in the trust, it would not be countable for qualification for Medicaid. So when we're concerned about Medicaid planning, or someone is in a nursing home and they may end up becoming a Medicaid recipient, the person who holds the power of attorney for them needs to be able to take assets out of their revocable living trust so that they can defend the assets and make them not countable for Medicaid qualification purposes. So, and then finally, the attorney, in fact, of course, has to deal with lawsuits. Hopefully nobody's subject to lawsuits. If anybody wants to ask me about whether they should sue or be sued, my typical response is, or get involved with lawsuits, my typical response is, don't. But unfortunately, that does happen with people. So if they become disabled, they need to have an attorney, in fact, to be able to take over decisions for them as a party. And also, where the trustee is a party to a lawsuit, the trustee, of course, makes those decisions. So that's an exception to the attorney, in fact's decision. But typically, if the person is sued individually or is involved in a lawsuit individually, they need to have an attorney, in fact, to take over for them. They also need someone to apply for public benefits and sign the application for them. And they might need to employ healthcare personnel. So that those people should be hired by the attorney, in fact, on behalf of the client, really not by the trust, because trusts can end up with substantial liabilities by having employees like that. So it's better to have the trust pay the employee, but have the employee hired by the patient through their attorney, in fact. And then, of course, finally, the attorney, in fact, needs to file personal tax returns for the disabled person, and those are some of the powers that are included in the special power of attorney for tax matters that we prepare for our clients. So that's a summary, essentially, of the three basic helpers, four basic types of helpers that people have during periods of their disability. And we want to make sure that the people who are the helpers have the education to know what their job is, and we can help them with doing that. So to the extent that people who have listened to this or been on the call, we'd like to congratulate them, because now they know what they're supposed to do, and that's the purpose of Nuts and Bolts. So at this time, we have about 10 minutes left. I'd like to just open this up to questions if anybody has them. So please feel free to unmute your phone or your speaker on your computer and fire away. Does anybody have any questions, concerns, comments?
Frank, this is Lou. I think it was a great session. I think this is going to be a great vehicle.
Good. I'm glad you liked it.
And I'm really going to need to have my helpers view this, so having it on recording is going to be essential. But this is, I think, a great step forward.
Good. I'm glad you like it. We'll be rather than sending out the links on a case-by-case basis, I think what we're going to do is just have a page on our website that people will be able to go to, and we'll have them sign in so that we know who actually signed in. And all they need to do is click on the link so they can go to the YouTube and have the education. And I think, Lou, that was your idea, so that we have people sign in to the education so that we know who they are and we can thank them. And then once they've done that, they are part of the Step 2 program, and they have that first call privilege that we have talked about. A lot of our clients don't understand that they have the ability to call us, and if we can answer their questions out of our experience without it being a project, we're very happy to do that. And that's just part of the program. There's no extra charge for that. So by having helpers be able to be part of the program, they're able to make those calls to us as well. Any other questions?
I couldn't hear the last sentence. I don't know what happened, but you faded out.
Oh, what did you hear?
You were talking about helpers being able to get on the website and all, but the very last sentence you said faded out. I couldn't hear what you said.
Okay.
I don't know.
Well, the purpose for having helpers actually sign into the website is so that we'll know that they've had the education. And then we can tell our clients that they've actually had the education and verify that for them. But once they have actually started with the education program and signed into the website, they then become eligible to the first call program. And the first call program is that our clients are able to call us up at any time and ask us questions. If we can answer the question from our experience on the telephone, we're happy to do that, and that's at no extra charge. If it turns into a project or we have to do some research or whatever, at that point we would talk to the clients about some form of a fee, but they would always know in advance of what that might be. But by having helpers sign in and listening to the program, what they're doing is qualifying themselves for the first call program.
Qualifying themselves for what? I couldn't hear the last couple of words.
For the first call program, so that they too can call us up and ask us questions, and if we can answer them, we're happy to do so.
Okay.
Any other questions?
That's it from here.
I think it's good, Frank.
All right. Well, hearing no further questions, I guess what we'll do is we'll finish this up. I just want to thank you all very much. Oh, one other thing. I want to make sure that you know that the second Tuesday of every month, starting probably in February, not January, but starting in February, will be the time when we do these educational programs. So, and that's going to be at noon on the second Tuesday of every month for an hour. So it's noon to 1. So if someone's in the East Coast, they can come in from their office on their computer and listen. And then, of course, if they can't make it, then they can go to the website and follow the link. The next second Tuesday will be in December. So the second Tuesday in December, I think that's December 10th. I'm not sure, but the second Tuesday in December will be the second part of this year's Nuts and Bolts program. We'll be talking about estate settlement. So I look forward to talking to you all then, and we'll of course send all of our clients invitations to that, call it a webinar or online meeting, and I hope to see you all then. So have a good day, everyone, and thanks for participating.
Thank you, Frank.
Thank you.
Bye.